plaintiff in this matter, Mindy Milleron. Ms. Milleron, good morning.
Good morning, Your Honor.
Next on my screen is the defendant, Mark Milleron. Mr. Milleron, good morning to you. Can you hear
Good
me?
morning, Your Honor.
Okay, there we go.
I can
So,
hear you just fine. Yes,
okay, good. So I've read your motion, Ms. Milleron. Did you get a copy of that too, Mr. Milleron?
I did. Yes.
Um, Here's what I know, and then the parties can fill in the blanks for me. The last uniform child support order was dated July 30th, 2024, approximately 1 year ago. The order provided for the sum of $970 for two children and $494.50 for one child. And what's interesting to me in those guidelines is that most of that appears to be childcare. And in fact, the motion alleges that there's a change in circumstance because the daycare costs increased. Isn't that something that's going to happen every single solitary year? So how in the world are we going to visit this every year, Ms. Milron? Because then I'm going to start hooking people up for court costs, because this is becoming a situation where I don't know how you or why you would want this in a child support order and not just in an order um, in the um, in the divorce case, right?
Yeah, I can definitely answer that. It will be a continuation until the youngest child, minimal, goes to regular school. He's going to be starting pre-K at the daycare this year because he's not old enough to start kindergarten until next fall. So they're both in full-time daycare and summer. I don't know what next summer will look like. Our daughter is also in before and after school programming. And I guess, I had definitely let their father know that it had increased at the beginning of the year, thinking that we wouldn't have to go to court and that it could just be made up. I don't know any other way to do it other than to file a motion, I guess, because I don't get additional funds unless it's written in a court order.
Yeah, that makes sense. But see, you have it written in a UCSO, in a Uniform Child Support Order. So what that means is that instead of just popping into court and or having the fees gradually go up, this is in a child support order, and every single year you're going to have to do it this way. Um, did um, did the attorneys representing you on the divorce suggest that's the route you go?
They they only presented putting it in the order as it was. I didn't know there was another way to do it.
Okay, all right. Um, Help me out, Mr. Milron.
Yes, sir.
Anything you want to add?
I certainly want to have to do this every year. I mean, the daycare costs are going to continue to fluctuate. As I said in my response, the daycare costs are actually going down here now that school is starting up because the youngest is going to be starting pre-K at the daycare, and the childcare amounts are actually going down for him as well as my daughter. Um, So if we were to grant the requested motion from the mother to increase the child support, I would then have to a month later file another motion to decrease the child support because it went down for the child care. I think there's some confusion in the UCSO what the line items are for.
I knew that was going to happen.
And boom, the judge spots the loophole. If daycare costs keep changing, does that mean endless trips back to court? Imagine paying lawyers just because daycare raised rates by $50. Should these be locked into flexible agreements, or is dragging it back into court the only way?
Because it was a unstable connection. We'll give him a second to see if he can.
I'm sorry, drop first here.
Yeah, turn off your camera, will you? You
It
turn off.
is off.
There's such a lag because
My
I
camera is off, sir.
still see you. There you go. Now, can you still hear me?
Yes, I can hear you, sir.
Perfect. So you make a good point. I mean, when are we ever going to have peace and quiet in this case? And we have to keep coming into court because daycare goes up, daycare goes down. Most people don't do it like this. There's other ways to do this. But here's what I'm going to do. I'm going to send this back to the front of the court, and they can come up with possibly another way to do this, maybe a 1 or 2 part order or something that's going to avoid you two from having to pop into court all the time.
Yeah, that would be great, to be honest. I just want half a daycare covered. That's really all I want.
Yeah, I mean, and if there's a separate order that just takes it out of this process, because then the parties can, if there's an order that says you're responsible for half the daycare, currently it's this, and in the future, if it goes up or it goes down, the parties will reevaluate, something like that. I mean,
Yeah.
maybe that can be done, but I'll send you over to the front of the court. Maybe they can help you with getting this thing taken care of, because I don't want you guys to have to keep spending time and money and all that stuff coming in here. Sound like a plan, Mr. Milron?
Yes, sir, it does. I hope that they'll be able to help us sort this out and understand the amounts.
Yeah, I think they will. They're pretty wise people over there. All right, I'll do the order of
They've
reference.
been very helpful every time I spoke to them.
Well, I'm glad. We don't always get that from people on the front of the court. So I appreciate that. And we'll see if we can't fix this for you both. Thank you.
Thank you, Your Honor. Appreciate it.
You can sign off.
Thank you.
All right. So let me see if I get this straight. On June 6th of 2025, this court heard the parties, did an order of reference, and the issue of parenting time was sent to the front of the court with the fees split. And apparently it was terminated due to the defendant violating my court order and not paying the requisite fees. Is that what I'm made to understand, Mr. Brooks?
Yes, Your Honor.
Here to explain, Ms. Ellsworth?
Yes, Your Honor. Good morning. I have had multiple conversations with Michael. I really would like to think that we can work together without having to do all of this. We've talked on the phone multiple times. We've had many conversations, which doesn't justify me not going to the court. I just really thought that with the history that we both have, that we could work this out together. We could come up with an agreement. We could have it signed and just go about our day. That didn't happen. So I do like to take into consideration the wishes of my daughter, of our daughter. Given the circumstance, I understand that I did have her move to Arizona. I understand that he's home now. And
Whoa, did you catch that? The judge just dropped the hammer. Pay up or face fines, maybe even jail. This went from daycare math to possible incarceration real quick. Fair warning or judicial overkill? What do you think? Should missing fees land a parent behind bars?
he would like to have visitation with his daughter, which I'm not opposed to at all. I reviewed his appeal, and I don't think that what he's asking for is unreasonable. I truly don't. The only issue that I have, Your Honor, is that her school is year-round where she's at in Arizona, and she has funky breaks. It's not like a Michigan school where we have like a chunk of time off for spring break or a chunk of time off for summer break. She has like 9 weeks on, 2 weeks off type thing. So I really just need to be able to coordinate with him. Not necessarily that I don't want him to see her, but just that we need to work with her schedule. She's in, in activities. She does, she does track, she does cross country, she does Bible studies, she does all sorts of things that she wants to get a job this next summer because she'll be of age. And she just really had begged her dad to understand that she wanted to be able to be a teenager at the same time as well as see him, but we never came to an agreement on that.
Mr. Brooks,
Yes.
your thoughts?
My thoughts on this are the back and forth of negotiations is not, we can't see eye to eye when it comes to parenting time, travel expenses. Obviously the child lives in Arizona, so that's a very drastic change of circumstances.
Yeah, I'm not that doesn't
It,
you're quoting legal stuff, and I think you're using it out of context. Go ahead.
but it doesn't bother me that she's in Arizona. What bothers me is just being able to establish parenting time.
Yeah, I
Getting
know. That's what that and I thought I solved this on June 6th, and here we are on August 15, and we're no further to that reality than when we were before. So I will do this. I'm going to send it back there. And this time, if the fees aren't paid, then there's going to be an order to show cause. And then Judge Gottlieb can decide whether someone should be heftily fined, incarcerated, whatever. I want to put an end to this. And the only way I can do it is if the parties comply with my orders. Okay. So I'm going to do it again. And so you're going to get this thing again. And if it's not paid this time, then there's going to be some serious consequences. Does everybody understand that?
Yes, Your Honor.
It's the only way I can do things. I would love the parties to be able to sit down together. In fact, the friend of the court may very well do that. But it's not happening right now. And I wish it was, because you seem like two very good people to me. And I hope you guys can get it together, but we'll see. If you can't, friend of the court will obviously make a recommendation to me. So I will prepare it again. And if you two want to talk, I encourage it. Most lasting agreements by parties last a lot longer than court imposed things. So take that for what it's worth, okay?
Can I add something real quick, Your Honor?
You only filed an objection to the recommendation.
Well, I was just, so she has cut off contact with my child, and I don't know what to do about that.
That first of all, that shouldn't happen, Ms. Ellsworth.
Your Honor, I did not cut off communication anywhere. Nowhere have I ever told Alexa she can't speak to her father. She is upset with her father right now because of what he's doing. She has expressed to him that she does not want to come back to Michigan, despite her, even I telling her that she needs to give her father respect, that it's her dad. But I have not cut off communication with Mike and his daughter.
If he calls, I want you to hand her the phone now. What happens at that conversation is between the child and Mr. Brooks. You can also write letters, but you're going to have to keep it together until the friend of the court does their magic. That's what I have.
Yeah, he's digging his own hole, Your Honor. So but I did not cut off no communication at all. And he would have to contact Grandma because that's where she's at. I'm in Michigan and she's in Arizona, so he knows my mom has had the same phone number for over 20 years, and he can call that number anytime.
I will prepare the order of reference. Call your daughter. See if you can make things right again, Mr. Brooks. We're adjourned.
All right. Thank you, Your Honor.
Thank you.